A Georgetown law professor was fired because on a Zoom call she expressed angst at the sad fact that in her experience of 20 years teaching at Georgetown, black students tend often not to do as well as their white counterparts. The man to whom she said that was also pressured to resign because he didn't respond and correct her. Bystander responsibility. What is going on in academia in this country? We've got the video you can watch for yourself on the Dershow. Today we're going to talk about race and academic freedom and free speech. As I've said before, talking about race is often difficult in the current atmosphere. Not talking about race is very difficult as well. So we're going to talk about it. We're going to try to talk about it in an honest and direct way. So the reason we're talking about it is Georgetown Law School, one of the great law schools in America, a school which has produced some of our best students, has some of the best faculty. It's a superb law school. Just fired an adjunct professor who has been teaching there for nearly 20 years because she discussed race on a Zoom. What happened was that there was a class being conducted on, I think, negotiation, mediation, whatever, and the class was on Zoom. And the students at the end of the class clicked off. And so the two professors were left talking to each other. And one of the professors said the following to the other: you know what? I hate to say this. I end up having this angst every semester that a lot of my lower ones are blacks, happens almost every semester, and it's like, oh, come on, you've got some really good ones, but there are also usually some that are just plain at the bottom. It drives me crazy. The other professor sat there and didn't say anything, apparently, something like that. Well, watch it for yourself in order to get a sense of the tone of the angst of the person who was saying this and the response or non-response by the person who was being spoken to. And then we can talk about what the proper response to this was, should have been, and was not. So listen and watch carefully. This is it. I mean, this is the only thing that was the basis for the firing. There's no allegation that this woman or the man have any history of racial discrimination or of having attitudes that are racist. This is it. This is the entire case for her being fired and for him essentially being forced to resign. So listen and watch carefully.
They were a bit jumbled.
Yeah.
It's the best way I can put it. It's like, okay, let me reason through that, what you just said, kind of thing. Yeah, right. Unfortunately. And you know what? I hate to say this. I end up having this, angst every semester that a lot of my lower ones are blacks. Happens almost every semester. And it's like, oh, come on. Get some really good ones, but there are also usually some that are just plain at the bottom. It drives me crazy.
Yep.
So I feel bad.
What drives me crazy is, the concept of how that plays out and whether that is, my own perceptions playing in here and with certain people, my own unconscious bias is, playing out in the scheme of things.
Yeah. Well, that's why, I think we do a good job of keeping track of did they open their mouths.
Exactly.
Well, here is the reaction of the dean of the Georgetown Law School. Again, a man with a superb reputation. He fires her after 20 years of teaching, calling the remarks, quote, abhorrent, and said, quote, it included reprehensible statements concerning the evaluation of black students? Well, you make your own judgment. Make your own judgment as to whether it's reprehensible, whether it's abhorrent. But what if a teacher believes that? What if a teacher really thinks there's a problem in law schools, particularly with blind grading? Now, this class maybe didn't have blind grading because it was negotiation and mediation, but when I was teaching at Harvard Law School, 150 students or 75 students or 80 students, we'd have blind grading. I wouldn't know what the race or gender or religion of my students was. They would be blind graded, and whatever happened, happened. And if I, at the end of a semester, was given the grades after you submit them to the office, you get them back with the names. So you can then look and see who you gave grades to. And if I had seen that the students in my class who are minority students weren't doing as well, I'd bemoan that fact. I'd wonder whether I was a successful teacher if I hadn't been able to create a classroom in which students were graded in a way that didn't, in the end, reflect any kind of racial or gender disparities. In fact, blind grading was introduced in order to avoid subtle, unconscious, even conscious sometimes, bias racially and gender or in any other way. I think I would bemoan that fact. And so a question arises of academic freedom. What if a teacher actually really believes that something has to be done about this, and she or he, regardless of what their racial background is, gets up and makes a speech or gives a class and says, look, this is a phenomenon that we are observing, and it's not a good phenomenon. We have to do better. We have to figure out a way of dealing with this problem. But the reality, the teacher says, whether it's true or false, is that in my classes, with blind grading or without blind grading, I notice that there is a racial disparity in outcomes. Is that really a fireable offense? Is that not a denial of academic freedom? Let me ask the question this way. The woman who was fired, the professor who was fired, was she fired because she believed that, or was she fired because she said what she believed? Now, there's no allegation, as far as I can tell, from the dean. He's not going to get into this. There's no allegation that what she said is factually false. The allegation is she shouldn't believe it, or if she believed it, she shouldn't say it. But what if she believed it? You can't control what people believe. She's been teaching 22 years. I taught 50 years. I have a set of beliefs about students. I tend not to think of students in racial or gender or religious terms, but one thing seems clear. There's always going to be some correlation, particularly in the old days. I think back to when Jews couldn't get into Yale or Harvard or other schools. Yale, when I was at Yale Law School, Yale College had, I think it was a 7% Jewish quota. Maybe I'm wrong by a number or two, but it was a very low Jewish quota. Surprise! Jews who got into Yale did very well. Well, of course they did very well. In order to get into Yale, if you were a Jew, you had to be exceptional and extraordinary. And if you were a WASP, a white Anglo-Saxon Protestant, whose father and grandfather and great-grandfather and great-great-grandfather went to Yale, you're going to get in on lower standards than you would get in if you were Jewish. And would it surprise anybody that the Jewish students who got in under the 7% quota, on balance, on average, in general, may have done a little better than the students who got in on their grandfather's coattails? That just seems logical, and I suspect it was supported by the empirical data, because I remember saying back then, people say, oh, Jews are so smart. No. We're not any smarter than anybody else. But if you're discriminated against and it's harder to get in, you're going to do better, especially if you work harder because you know you don't have belt and suspenders or a parachute. You know when you get out. Look, I've told you this story before. First in my class, Yale Law School, editor-in-chief, Supreme Court law clerk, turned down 32 out of 32 Wall Street firms. Of course I'm going to work harder. than my friend whose father was a DuPont and whose grandfather, was a Taft. It's just logical. And so the question is, was she entitled to believe what she said based on her 20 years of experience? And if she was entitled to believe it, was she entitled to say it to a colleague, a teacher, on a Zoom call that she believed had ended with the students and was just between her and the professor? Is there no privacy interest involved here at all? Okay, put that aside for a minute, because I take the position, not only was she allowed to say it to a colleague, she would be allowed to have a class or in which she expressed that as a hypothetical or as a possibility and had discussions about it, a class on racial equality, and expressed that view and said, what should we do about it? She certainly should be entitled to have a speech, make a speech in which she says, look, I've been teaching for 20 years and I've observed this phenomenon. There's something wrong with it. We have to change it. We have to make it much more equal. We have to make sure that we're doing a better job, etc. Why is there no concern about her academic freedom, about her freedom of speech? What about students who agree with her? Are they not entitled to hear her views expressed? Are her views verboten? Are they somehow not permitted to be expressed? Let me give you another hypothetical. This is not so much a hypothetical. Georgetown is a Catholic university, independent, but a Catholic university. The Pope today announced that he would not bless gay marriages because the Catholic Church regards homosexuality as a choice and a sin. What if a professor in a class said, by the way, the Catholic Church has regarded homosexuality as a choice and a sin? Would that be a fireable offense, restating what the Pope has just said? Would it be a fireable offense for a Catholic professor who believes that the Pope is infallible to say, not in class, but in a conversation with a fellow Catholic, by the way, I'm really glad the Pope finally had the courage to say what we know everybody in the Catholic Church should believe, etc., etc. Would he not be free to make that statement? Is there a difference between what was said by the woman who was fired and my hypothetical Catholic professor? Or what if it wasn't a Catholic professor? What if it was a Jewish professor or a Protestant professor? Are you allowed to attack the Pope? Well, no, it's a Catholic school. You can't do that. Are you allowed to agree with the Pope? No, that would be agreeing about a bigotry regarding homosexuality, sin, choice. So what's the answer? You just have to keep your mouth shut. That's not enough, keeping your mouth shut. The other professor on the video kept his mouth shut. He may have, he's polite. He now has said in a kind of mea culpa apology that he should have done more, that he didn't agree with what was being said, and the dean talked about bystander accountability. So even silence is not an option. You can't not talk about race. You can't not talk about homosexuality. You can't not talk about any of these difficult issues. But if you do talk about them, you darn well better say what is politically correct and what is acceptable, because if you don't, you're going to get fired. If you remain silent, you're going to get fired. And who knows what is politically acceptable at a Catholic university regarding homosexuality? I don't know. And I don't know what's acceptable discussion regarding race, affirmative action, grading, all of that. Those are very difficult issues and they should be talked about, but not at Georgetown Law School. You cannot talk about it. You cannot remain silent about it. And if you're going to talk about it, you better say the right thing. But what's the right thing? What's the right thing? Is the right thing to say black students do better or just as well, or affirmative action has had no impact on grading? What's the right thing to say? Are you obligated to lie? Are you obligated to say something you don't believe? Are you obligated to believe things that may not be true? What is the way out of this dilemma? I have to tell you, I thought Harvard University had violated academic freedom in the worst way when it fired Ron Sullivan. Fired him. Some of my friends say he wasn't fired, he just wasn't renewed. Well, of course he was fired. If you're not renewed and you're expecting to be renewed, you're fired. No question about that. So I thought the firing of Ron Sullivan, because he represented for about 15 minutes Harvey Weinstein, was the worst abuse of academic freedom in my modern adult life. Obviously, McCarthyism was worse. But now I think Georgetown is worse, because Georgetown is firing a professor for expressing a heartfelt belief that may well be true, maybe false, maybe true, maybe somewhere in between, but nobody has claimed it's false. That's not the basis of the firing. So you can be fired, again, for saying something that may be true, that you honestly believe, and that you want to present as a problem to be solved because, to quote her again, I have angst. This is terrible. It drives me crazy. She's not applauding this. She's bemoaning it. And to get fired because of that, I don't think I have seen any worse example of academic freedom. If this were a public university, I think the university would be sued, and appropriately so. It's a private university. But there are contract rights as well. And there are civil liberties and civil rights. And even if there's no legal remedy, it's just wrong. And then the response is so dangerous. So the person who was just sitting there and saying nothing, what happened to him? He has been placed on administrative leave and was to have no further involvement with the course. And of course, at that point, he was pressured to resign. And he resigned for his silence. The other professor, she had to, it's like a Chinese culture camp during the Cultural Revolution, where you had to confess your sins and you had to admit your wrongdoing. Here's what the professor who was fired said. She's deeply sorry for her hurtful and misdirected quotes. I have done irreparable harm, and I am truly sorry for this. That's even worse than being fired. Having pressure on you to admit and acknowledge that the angst you felt in your heart, that the difficulty that you felt, your desire to solve a problem, your desire to do the right thing, your desire not to be driven crazy, you have to admit that that was reprehensible and abhorrent. There's something very, very wrong with that. The chilling effect it places on people. The other professor, the one who was silent, also had to apologize. He missed the chance to respond in a more direct manner to address the inappropriate content of these remarks. Missed a chance to respond. So now all of us are on notice. If you hear any colleague say anything that is politically incorrect, you must immediately and impolitely jump in and say, shut up! No, you're wrong! I don't want to be associated with that. Turn off the Zoom. That's not the way people react. People make statements and people say, I don't agree, but I'm not going to say anything. I'm polite. We teach together. We've been teaching together for years. Why is that? Bystander sin. Bystander sin. It's not as if we're talking about being silent in the face of overt bigotry. It's not as if somebody used the N-word or something else and you say, no, this was a conversation, a reasonable conversation. This was a confession by a woman who had angst and felt terrible and was being driven crazy by what she saw, and nobody claims that what she said she saw is false or wrong, but she shouldn't have said what she felt. She shouldn't have said what she believed. Now, I just want to contrast that, what happened at Georgetown, with what happened last night on the Grammys. Last night's Grammys honored and had as a performer a woman named Tamika Mallory. She sang a song about Biden. It wasn't even a song. It was just a kind of statement to music, a rap statement demanding that President Biden do justice. This is a woman who is an overt anti-Semite, who has made horrible statements about Jews, who has said that Israel doesn't have a right to exist. She has praised the Reverend Farrakhan. She was kicked out of a leadership position in the Women's March because of anti-Semitism and bigotry. The Grammys didn't fire her. They rewarded her. They praised her. They gave her a place of honor, along with Jay Electronica, another musician who has had overt bigotry in his past and perhaps in his present and now in his future. If you're Electronica or Mallory and you say, hey, I made all these horrible anti-Semitic statements, I've supported one of the biggest bigots in the world, the Reverend Farrakhan, and I'm getting honored. I'm not getting fired, I'm getting honored by the Grammys. I'm going to keep doing it. Can you imagine if a white country singer had praised David Duke or had used David Duke's speech in his lyrics to a song or had shown some support for David Duke? Would they be honoring that person? Of course not. Well, Farrakhan is the David Duke of modern times. Farrakhan is as big a bigot, as horrible a human being. He is anti-gay, anti-woman, anti-white, anti-Jewish. You name it, he's anti. And Tamika Mallory is pro and promotes him and promotes bigotry, as will Jay Electronica. Let me be very clear. Mallory did not win a Grammy. Had she won a Grammy, it would be more difficult. Do you take away a Grammy from somebody who deserved it based on her performance because she's a bigot and an anti-Semite? That isn't the question that was presented. She didn't get a Grammy. She didn't deserve anything. She was just honored by being asked to perform, a rare honor that very few people get. The Grammys could have picked anybody, but they picked a bigot. They picked an anti-Semite. They picked somebody who supports Farrakhan, who's anti-gay, who's anti-white. That's who they picked. That was their choice. And my choice is to condemn them for it. So what kind of a world are we living in? On the same weekend, we see a woman and a man, one fired, the other pressured to resign, for honestly expressing real angst about the problem of race in America. In the same weekend, we see two bigots get Grammys. Anti-Semitic bigots and anti-white bigots get Grammys. On the same weekend, we see the Pope announce that the Catholic Church now believes that homosexuality is a sin and a choice, and that the Catholic Church won't recognize it. And we see at least the possibility of, how do you discuss those issues? How do you have a reasonable discussion at Georgetown University about the Pope, about Mallory, about grading? I have to tell you, the message of Georgetown University is keep your mouth shut. Do not nod in agreement. Just sit there stone-faced, or else just don't have conversations. Sorry, is this a conversation about race? No. I'm turning off the Zoom. Is this a conversation about homosexuality? Oh, no. There's no right answer here. I'm turning off the Zoom. I have to tell you, what's happening in academic settings today, the denial of academic freedom is worse than McCarthyism. Worse than McCarthyism. When I was at Brooklyn College, at least we, the students, didn't have to worry if we expressed our honest views. McCarthyism was rampant, but it was nothing like this. This kind of left-wing, politically correct, racial justice McCarthyism is going to destroy American universities. It's going to destroy academic freedom. It's going to destroy freedom of the press. And we have to fight back. And on the Dershow, I will fight back. I will always express my honest views. Thankfully, nobody can fire me. Nobody can call me in and make me apologize for believing what I believe and expressing what I believe. And I hope you'll do the same thing. So call into the Dershow. Tell me your honest views. I hope you don't express views that are racist or sexist or homophobic. You're free to express whatever views you want. but certainly let's have a rational conversation about these difficult issues. Not at Georgetown University. If you're a professor at Georgetown University or a student, keep your mouth shut. Do not get involved in conversations about sensitive or difficult issues. Silence, no, without nodding. Silence alone won't protect you. If somebody says something, you have an obligation to speak back. Otherwise, you're guilty of bystander crime. What a world we've come to live in. I have to tell you, interested in your views on this subject, you've heard mine on The Dershow. Now it's time for your calls. First caller.
Professor Dershowitz, my name is Stephen. I'm calling from Manhattan. Your show has grown to become essential listening for me, so thank you for that. My question pertains to your episode, Are They Overcharging Chauvin? Firstly, I like the format of that episode and request that you do more like that. I was appalled and outraged at the George Floyd death. My personal belief is that Chauvin knew what he's doing, but nonetheless, I still have this question. I agree that your assertion that Chauvin case is manslaughter. Agree with your assertion that it's manslaughter too, but your assertion hinges on Chauvin having knowledge that he was risking harm. But shortly after they released, I read all of the 20 or 30 pages of the transcripts of the police body cams, and I was starting to see that Floyd was saying that he couldn't breathe long before he was restrained and placed in the police vehicle. In fact, he was being restrained outside of the vehicle because he refused to get into it because he, in his own words, was suffering from a panic attack, having been involved in a previous police shooting. So lastly, in addition to this information, Minnesota police released slides of their training manuals, which show an almost identical kind of textbook position of restraining people on the ground safely, the way that Chauvin did. So given this, is it really clear that based on the evidence that Chauvin was aware of the risky behavior he was engaging in, and consequently that this was an obvious manslaughter 2 case? I eagerly await your response. Thank you.
That's a great question. You would be an excellent defense attorney. These are issues that will obviously be raised at trial. I was focusing on the statutory language, but you're absolutely right. One has to look at the evidence. If, in fact, police officers were trained to do this, then it would be a hard question whether or not he went beyond the training. You're right. One has to ask about the breathing. But if he said, I can't breathe because he had a pre-existing condition, and if Chauvin knew about that had a breathing problem, that certainly should have influenced his decision to put a knee on the neck for as many seconds as he did. These are all issues that will come out at the trial. The question remains, will he be able to get 12 jurors and a judge who are uninfluenced by the pressures outside and uninfluenced by the fear that there might be violence if there were to be an acquittal in this case?
This is Itzhak Bassman again, calling from Toronto. I just heard your excellent analysis of the charges facing Chauvin, and it was so straightforward and clear that I found it to be the best of all that I've read about what he's facing. And you were especially lucid on the idea of proximate cause. It certainly straightened that out in my mind as I was struggling with how it would go if it was just a contributing cause to Floyd's death. The one question I have, and one point either you glossed over too quickly or I didn't quite catch, is the notion of culpable negligence and focusing on the element of culpability, which is to say that if the knee on the neck was in line with Minneapolis police protocols, would culpability even arise? That's my question. I guess just to flesh that out a bit, if knee on the neck was part of the protocols, would there be an issue about overusing it or some situational qualification that would go against the claim that it wasn't culpable because it was in line with the protocols? If you could just elaborate on that a little bit, I'd be very obliged. Thank you very much. And again, your analysis was just excellent. Thank you. Bye.
Mm-hmm. Well, thank you. Another great defense attorney. You've raised all the issues that I think will come up at trial. Obviously, part of the defense will be that it wasn't culpable or negligent because he was simply following the guidelines that were outlined by the Minneapolis police. Well, we have to wait to hear. I'm told that's contested, that was no longer the guidelines. But even if it was the guidelines, you have to look at the entire thing in context. Did he know the person had a breathing problem? Was it necessary to use that option of knee on neck? Could he have used a safer option? All of these will come up, but you're absolutely right. If the Minneapolis police have trained their officers that knee on the neck is appropriate in this situation, it would certainly strengthen his defense that what he did was not negligent or culpable, but the result was simply a tragic accident. I think the American public would find it hard to accept that, but maybe the blame belongs to the Minneapolis Police Department training program rather than the individual, or maybe it's a shared responsibility. Again, being a defense attorney in a case like this requires extraordinary creativity, talent, ability, because the odds are so against you. You know, we hear about the presumption of innocence. In a case like this, there is an overwhelming presumption of guilt that has to be overcome by absolute proof of innocence. And getting the guidelines from the Minneapolis police would be a big step in the direction of establishing innocence. Because I think most Americans watching that video say to themselves, that's just not right. It's probably criminal. We don't know. We're not criminal lawyers, but it's just not right. And shouldn't the law reflect what's right or what's wrong? Well, the answer to that is not necessarily. There could be things that are wrong that shouldn't be criminal. And remember, police have to make decisions on the spur of the moment often. This seemed, based on the videotape that I saw, unjustified. But I have an open mind, and if I were a juror, I'd wait and listen to all the evidence, including whether or not the Minneapolis police authorized that kind of restraint. So let's wait to hear what unfolds at the trial. We'll have more discussions about this case on the Dershow.
Greetings and felicitations, Professor Dershowitz. J.R. Green from Queens, New York. Appreciate the legal review of Murder 2 and 3 and Man 2 in the Officer Derek Chauvin case. If I, as a juror, am charged with holding the default opinion that Officer Chauvin is innocent because of the doctrine of the presumption of innocence, then unless the prosecution can prove by the evidence beyond a reasonable doubt that Officer Chauvin disobeyed his police academy training, violated Minnesota law at the time of the incident by using a neck restraint, which I've read was legal in the jurisdiction of Minneapolis in May of last year and had been used a couple hundred times in the previous 5 years without incident, that Mr. Floyd's cause of death was asphyxiation or other form of lethal trauma attributable to the allegedly legal restraint and not due to the combination of a lethal dose of fentanyl in combination with meth, morphine, and traces of carfentanil, which is 100 times more potent than deadly fentanyl, exacerbated by the presence of SARS-CoV-2 and enlarged heart and free blocked arteries, as appeared in his official autopsy report and tox screen. Given that he began to complain he could not breathe well before he asked to be placed prone on the ground while waiting for an ambulance to arrive, and that the manner of death was homicide and not either accidental or suicide via the injection, and or whooping of lethal drugs, or undetermined, then my opinion could not change, and I would have to dutifully and lawfully communicate my opinion via a verdict of not guilty. Please respond, and if you're so inclined, rebut me. Thank you.
I'm not going to rebut you. You make a very good point. I think the combination of, if in fact there was a regulation that authorized the use of the knee on the neck, number one. Number two, if the major factors contributing to death, if why this person uniquely died rather than the dozens of others who were subject to a similar constraint, why this person uniquely died were the drugs in his system, that would be a very, very powerful defense. And you'd be a great defense attorney because, and frankly, I hadn't thought about that. I hadn't thought about it until you mentioned it. The combination of the training, the fact that it's been done over and over again, if this is true. I don't know whether this is true. I've heard it, I've read it, I want to see the evidence. But if in fact it's true, that knee on the neck has been used many, many, many times without fatalities, and that the reason that this case was different, that a fatality resulted, was not that the knee on the neck was different than previously used, but the fact that this is a person who had all kinds of voluntary drug ingestion. That combination together would make for a powerful defense. I mentioned before the eggshell skull doctrine, in which some courts have applied it in criminal cases as well. That is, you take your victim as you find them, and if what you did was wrong, the fact that the person died because of a pre-existing condition may not negate criminal liability. Now, it depends on what the pre-existing condition is. If a person has a weak skull because he was born that way, that's one thing. But if a person has a special vulnerability to knee on the neck because that person voluntarily and illegally ingested lots and lots of drugs, that may very well cause a different outcome. These are really, really interesting issues. These are the kinds of issues that I would spend the whole hour on in my class in first-year criminal law at Harvard Law School. And in the end, I would not give my students my opinion, because in 50 years, I don't express opinions. I just try to teach students how to think, not what to think. And I don't have to teach. The three callers that I've gotten up to now really, really have had sophisticated approaches to problems of causation and problems of multiple issues like training. So you've thought it through for yourself. I think it's important that you come to this problem without any kind of predisposition.
Hi, Professor. This is Mike from Kfar Sava, Israel. My question regards the Derek Chauvin case, and I'm wondering if the prosecutor actually has the right to charge Derek Chauvin with 3 different charges and leave a multiple choice test for the jury, or isn't it the responsibility of the prosecution to come with a specific charge? It almost seems like this is a use of behavioral economics to put 2 charges which are absolutely not relevant to the case because they feel that they can't get man 2. If they could get man 2 straight off, they would get it. Here they're implying to the jury that there are other charges. The jury would say, oh, these other charges are totally ridiculous. Compared to those charges, they could get behind a man 2 conviction.
A great, great question. Again, I have won some cases based on multiplicity of charges, but the prosecutors do it all the time. They charge A, B, C, D in the hope that maybe there'll be a compromise verdict and they'll split the difference and go somewhere in the middle. That's wrong, and a good defense attorney will make arguments for a multiplicity of charges, require that the prosecution pick a charge. The jury instruction will sometimes alleviate that problem, sometimes will exacerbate the problem, but you put your finger on it exactly. I think one of the reasons that they charge second and third degree murder rather than the obvious crime of second degree manslaughter is they wanted the headline that he's charged with murder. Murder is what people think happened there. So if they had failed to charge him with murder, I think the Attorney General and the other prosecutors would be highly criticized. And that's not the reason they should make their decisions. They should make their decisions based on the law. I agree with you. I think the only charge in this case should have been second-degree manslaughter. You can argue that there is a reading of the third-degree murder statute that permits for it to be applied to anybody who endangers the life of others, and others mean anybody other than the person himself. That's not, to me, the best reading, but it's a plausible, stretched reading. But second-degree murder is just off the table. It's just not there. There's no possible basis for a second-degree murder prosecution in this case. It just doesn't fit any of the criteria. So overcharging is common. Overcharging can sometimes result in a compromised verdict, which is a victory often for the prosecution. Sometimes it can result in an acquittal. Jurors don't like to be told that the person was charged with something that was obviously the facts just didn't fit the charge. So charging is often a political decision. This prosecutor is highly political and has a history of bigotry and racism and anti-white attitudes. He was a big supporter of Farrakhan. And so one has to really question the decision to impose multiple charges. I agree with you. I think if I were a defense attorney, I would demand first the removal of second-degree murder, which I think he has a very strong basis for removing based on the facts. And then third-degree murder, I would argue that since there was no danger to any other people, that's inappropriate as well. I suspect that will not succeed. Already the Court of Appeals has remanded the case and said you have to consider the third-degree murder charge. I think that was a mistake, but that's the law at the moment in Minnesota.
Hi, Alan. This is Martin from Florida. I have a comment with respect to the 7-foot guy named Miles who made the anti-Semitic remark of kike. Here's my comment. First of all, what if he had said the N-word? And what kind of rebuke would he have had then? I think it would have been pretty serious. Now you could say, well, not as many people know the word kike. I don't accept that. I think you're wrong. I think a lot of people know what kike means. And frankly, I'm offended. I'm Jewish and I'm damn offended, frankly. And I think he should be penalized however harshly they're going to penalize him. This guy's paycheck comes from a Jewish guy who happens to own the Miami Heat. So no, I don't accept that for a minute. And I think he should be penalized just as severely as if he used the N-word. Frankly, I'm tired of Jews having to lay down and say, oh, but he didn't mean it. He didn't mean it. I don't care if he didn't mean it. As a lawyer, you know, as well as anyone, that ignorance of the law is not an excuse from it. The same thing occurs here. The same thing. Ignorance of the word doesn't give him an excuse to use it. And if he's going to be that simple-minded and naive, he should be punished for it. Let him learn what it's like at the other end of the situation, or if the shoe were on the other foot, whereas he was a Jew and he knew what the word kike meant and somebody used it. Let's see how happy he'd be then. No, I don't accept it. This guy needs to be harshly rebuked or whatever's going to occur to him from a penalty point of view. And I think it's particularly ironic that a Jewish guy is paying his salary. That has to be confronted. That has to be understood. Because frankly, if I were paying this guy's salary, I'd be damn upset.
That's a good point. Let me correct one point. Mistaking the law, making a mistake about the law is not a defense, but mistake of fact is often a defense. If you don't know what a word means, it would be a defense. I don't know whether he knew or didn't know, whether or not it was something that was tossed around in his family. I just don't know the answer to that. My feeling is that the K word, the kike, is not as bad as the N-word. The N-word has a long, long, long history. The K word has a history too, not nearly as malignant. As a Jew, I'm deeply offended. If somebody called me a kike to my face, it would be comparable maybe to the use of the N-word, but he didn't. He was just screaming and yelling. You know, he was playing a game. So I'm a forgiving person. The fact that the team is owned by a Jewish owner, look, the Jewish owner could have imposed whatever penalty he wanted. The NBA can impose penalties, but so can the owner of a team. The owner of the team could also fire the person for just cause, but he didn't. They gave him a $50,000 fine and a week suspension. I think I would have gone to $500,000 fine, maybe $1 million fine, a fine that had an impact, a fine that meant something, $10,000, $50,000, I'm sorry, on a $10 million salary is a slap on the wrist. And a week suspension is nothing because he's injured. So I think it was mostly symbolic. And I think the symbolism might have been a little harsher, but I would not have fired him. I think he's learned his lesson. I don't think he'll ever use that word again. As I told you, when I was teaching many years ago, a student, really well-intentioned student, the nicest guy in the world, raised his hand and talked about how he would Jew down at the prosecutor and try to get a lower sentence. The guy just didn't know what he was doing. I mean, Jew down was something that was spoken about around his house. People don't think about it. You know, we use the word gypped. That comes from gypsy. We use the word welch on your bet. That comes from being from Wales. We use the term Indian giver. I would never use that term because that's so obvious. And indeed, it means the opposite of what we intended to mean. Remember the famous story, whether it's true or not, that the settlers in New York, the white European settlers in New York, bought Manhattan for $24, and they kept it. So I don't like those terms, but they become part of our vocabulary. Kike is not, thankfully, part of our vocabulary. It was wrong for him to say it. and it was right for him to be punished, and I think he should have been punished more severely, but it was not, for me, a verbal capital offense. It was a kid yelling and screaming while playing a game and using words that he'd probably heard used when he was a kid and may or may not have known the full meaning, certainly didn't know the origin of the term, because very few people know the origin of the term. So let's be forgiving. But you're right. Let's apply a single standard. Let's make sure. And look, what happened at the Grammys yesterday is so unforgivable. The idea of honoring somebody with allowing her to perform when she has this horrible history of bigotry, racism, anti-Semitism, never would have happened to somebody who had a comparable history of anti-black attitudes. So we need a single standard. That's my view on the Dershow. I want to hear your view. I want to hear from everybody. Please tell your friends, those of you who enjoy my show, tell your friends that they'll enjoy it. Subscribe, and let's keep making controversial, and let's keep talking about difficult issues on the Dershow. An important part of the Dershow is your voice, your questions, your comments. Please call 24/7. The number is 216-710-0050. Keep your comments short and to the point. Again, the number for you to call 24/7 is 216-710-0050. Hard questions, criticisms, everything's fine. Just keep your questions short, and I'll answer them all on the Dershow.